I'm going to talk to you today a little bit about estate planning. Estate planning can be defined as setting up property ownership and debt payment in a way that you deem best. What constitutes your estate is whatever property you own at the time of your death, minus any debt. Estate planning allows you to decide who will inherit your property. It will allow you to plan your estate to include the guardianship of your children and of their finances if that's necessary. You can also appoint someone to make financial decisions and healthcare decisions in the event that you're unable to do so yourself. If you plan your estate in advance, it can minimize probate fees and also federal estate taxes. Estate planning as a whole contains certain basic elements which are essential to protecting your family and protecting your assets. One of the first steps would be to create a will and a trust. Both a will and a trust are often needed in order to provide a complete or full estate plan. If you'd like to completely control your estate, a will and a trust would be the best way to do so. A will direct what to do with your property at death. You can appoint a personal guardian for yourself and you can take care of property that you buy or inherit shortly before your passing. You can take care of any property that you own that is not placed in a trust. And many don't know this, but a will can also disinherit a child. A trust, on the other hand, is the appointment of someone to control your property for the benefit of someone else, namely you. A trust will help avoid very expensive probate proceedings. It will help avoid legal fees. And if you only have a will alone, the executor of your estate will still have to deal with probate courts in order to authenticate your will, to appoint a permanent executor, to pay your debts and taxes, to identify your heirs, and also receive court approval before they collect your assets and distribute them as your will specifies. A will can even create a trust in it. We call that a testamentary trust. The second step in planning your estate plan is establishing a financial power of attorney. The primary reason to establish a durable power of attorney for finances is to avoid court proceedings in the event that you become incapacitated. If there is no financial power of attorney, your spouse, your relatives, your loved ones, they may have to initiate conservatorship proceedings. This can be very complicated. It can be expensive and it can be very embarrassing. Most importantly, it's not guaranteed. Your loved ones must ask the court to appoint a conservator, and there's no guarantee that the person who the court appoints is the person you would have appointed. Without a durable power of attorney over your finances become within the power of the court. Now, the next aspect to basic estate planning is creating a living will or a medical directive. A living will allows a person to set out wishes about what treatment should be administered or withheld if you become unable to communicate those wishes. This provides you with the ability to direct doctors to provide the medical care you want or to not provide particular medical care. Finally, the last step is making final arrangements in advance. This step can be most helpful to loved ones immediately after one's passing. By planning what you want commemorated, you take the additional worry off of your family and friends during a very difficult time for them. By planning, you can also lower the cost of after-death goods and services by taking care of them now. Many companies offer reduced rates for planning ahead. Your advanced planning can also allow for comparison shopping, and this can also keep costs to a minimum. With these 5 basic steps, the protection of your estate and your wishes would be ensured. Before the time of grief and mourning, important medical, financial, and personal decisions should not be left unattended. If you determine that you need to or would like to discuss any of these estate planning techniques at any time, we encourage you to give us a call. Estelle and Kennedy Professional Law Corporation. You can call us at 909-608-0466. We'd be happy to serve you and meet your needs. Thank you.